Welcome back to the Deep Dive, the place where we give you that shortcut to understanding complex stuff. Today, we're opening up the rulebook for debt, really getting into how interest gets calculated legally when there's no contract saying how. We're talking about the Prescribed Rate of Interest Act 55 of 1975. Okay, let's unpack this a bit. You see an act from 75, right? But then you notice it's been updated like just recently, September 2025. That tells you it's pretty fundamental. Our mission today is really to get why this act has stuck around for so long and is still so important. Basically, it's the law's default setting for how much interest you owe if you haven't agreed on a rate or, if the court orders a payment.
Exactly. That mix of fundamental stability but also constant tweaking is what makes it fascinating. It's the benchmark, really. When it first came out back in 75, the whole point was just to have a way to calculate interest in some situations and also for setting the rate on judgment debts. But the key thing for you to grasp is that this isn't some dusty old law sitting on a shelf. No way. It's had some major updates to keep up with, modern finance and consumer rights. We've seen big changes from the Amendment Act in 97, then the huge National Credit Act in 2005, and the Judicial Matters Amendment Act in 2015. It really is a living piece of law tied directly to how our economy works now.
That makes a lot of sense. So if it's the default, when does it actually kick in? What flicks the switch for the statutory rate? And crucially, how do you calculate it?
The trigger is, pretty straightforward. The act applies if a debt is supposed to bear interest, legally speaking, but the rate itself isn't already set. So if there's no other law dictating the rate, no signed contract clause, no established way things are done in that particular trade or any other kind of agreement, then the act steps in. If there's silence or maybe a fight over the rate, this act gives you the answer.
And what is that answer? I guess it's not just some fixed number they picked back in the 70s. You said it's dynamic.
Right, exactly. It moves with the economy. The formula is actually quite clear. The rate is the repurchase rate. That's the repo rate, which is set by the South African Reserve Bank, SARB. And then on top of that repo rate, there's a fixed addition plus 3.5% to annum.
Okay, repo rate plus 3.5%.
Yeah. And just so everyone's clear, that repurchase rate, or repo rate, that's the main interest rate in the country. It's the rate banks pay when they borrow rands from the Reserve Bank. So the moment the ARB changes its policy rate, this legal default interest rate starts shifting too, always carrying that extra 3.5%.
Okay, here's where it gets really interesting, especially if you're trying to figure out legal risk timing. If the Reserve Bank hikes the repo rate today, does this prescribed rate jump up instantly?
No, it doesn't. And that little delay is actually quite important administratively. When the SARB changes the repo rate, the Minister for Justice has to officially publish the new rate in the Government Gazette. But here's the key bit. The new rate only actually starts applying from the first day of the second month after the month the SARB made the change.
Ah, okay. So there's like a built-in notice period. If the SARB changes the rate late in October, the new legal rate only kicks in on December 1st. You'd need to factor that lag in if you're in the middle of a dispute, right?
Precisely. You have to account for that lag. And we know this happens regularly. Like you mentioned, there was a recent notice setting the rate at 10.5% per year, starting September 1st, 2025. It follows that exact calendar mechanism, keeps things, responsive but also predictable.
Okay, but with all this, like mathematical precision, repo plus 3.5%, can a court still say, hang on, that doesn't feel right for this specific situation? Maybe that 3.5% premium seems way off for a particular kind of debt.
Oh, absolutely. The Act gives judges that flexibility. It's like a safety valve. A court can order a different rate if it finds there are special circumstances related to that specific debt. That ensures, that fairness can win out over just applying the formula rigidly, especially in really unusual cases.
Right. Okay, let's shift gears. What about money that a judge has already ordered someone to pay, what the Act calls judgment debts?
Yeah, Section 2 covers this. It's designed to stop people from delaying payment just because they can without facing interest costs. So the rule is, if a court orders you to pay money, that's the judgment debt, that amount automatically starts earning interest from the day it's supposed to be paid. It follows the prescribed rate unless, and this is important, the judge's order specifically says something different.
Okay, so interest starts running immediately on the judgment amount.
Yes, and it's important to know what counts as the judgment debt. It's the main sum the court ordered, plus any legal costs they awarded. It doesn't, however, let you calculate interest on interest that might have already built up before the judgment. It's focused on that principal amount decided by the court and the costs.
And the Act makes collecting that interest pretty strong, doesn't it?
That's right. Any interest that racks up after the judgment can be recovered just as if it were part of the original debt itself.
So whatever legal tools you have to chase the main debt, you can use them for the interest too.
Exactly. It gives the creditor the same enforcement power for both. Oh, and just a historical note, this rule about judgment debts wasn't retroactive. There's a clause making sure it didn't apply to debts that were payable before the act actually started back in July 1976.
Got it. Okay, now for what feels like the trickiest bit in court cases. Unliquidated debts. This is where the amount of money owed is still being argued about, right? Like damages after a car accident where you don't know the final medical bills or lost future income yet. How does interest work there?
Yeah, this is Section 2A, and it's a really significant part of the Act for creditors. The basic rule is once that fuzzy unliquidated amount is finally nailed down, whether by a judge, an arbitrator, or the parties just agree, it will bear interest. And it bears interest using that same formula we talked about, repo rate plus 3.5%.
Okay, but when does the interest start? That seems critical if the fight over the amount takes years.
It is critical. The Act says interest starts running from the date the creditor formally claims payment. That means the day they serve the debtor with either a formal demand letter or a court summons, whichever comes first. So sending those official papers isn't just telling the other side you're serious, it's literally starting the interest clock, even if the final number isn't known for ages.
Wow, okay. So that initial demand or summons date is huge.
Yeah.
And what counts as a proper demand? You can't just text them saying, you owe me, right?
Yeah. No, definitely not. The Act is specific. It has to be a written demand. And it needs to lay out the claim clearly enough so that the person receiving it, the debtor, can actually make a reasonable guess about how much is being claimed, the quantum. It forces the creditor to be, reasonably clear from the get-go. Now, this leads to a really important exception, especially for, say, law students listening or anyone dealing with claims about future losses. Think about compensation for future medical care or lost income years down the line. Interest on the present value of those future losses doesn't start running right away. It only starts from the date that future amount is actually finalized by the court or through settlement. You shouldn't be paying interest today on money meant for a loss that hasn't happened yet.
Okay, that makes sense. You're penalized for delaying payment on current or past losses, but not on amounts calculated for the future. What if the debtor actually wants to pay something to stop the interest clock, but the creditor is still arguing for more? Is there a way to do that?
Yes, there is. It's about interrupting the running of interest. Usually this happens through what's called a tender or a payment into court. If the debtor makes a formal offer to settle by putting money down, either with the court or directly as a tender, the interest stops running from that date on the amount tendered. Then, if the creditor eventually accepts that amount, or if the court ends up awarding them less than what was tendered, the debtor has successfully stopped the interest clock for that portion. It's a really useful tactic in settlement talks. And just to loop back to what we said earlier about judges having the final say, even with these detailed rules for unliquidated debts, a court or an arbitrator can still make whatever order they think is just about the interest. They can adjust the rate, change the start date, decide how it should be paid. They still have that ultimate power to ensure fairness, even while working within the Act's framework.
So let's bring this back to the real world. We've talked about this link to this SARB repo rate. What has that actually looked like over the years? Has it made a big difference?
Oh, a massive difference. It means the cost of owing money legally isn't fixed at all. It directly reflects what's happening in the wider economy. If you look at the history of the rates published in those Gazette notices, you really see the impact. I mean, get this. For something like 20 years, basically from 1993 all the way to 2014, the prescribed rate was stuck at a really high 15.5% per year. Imagine owing money during that time.
Wow, 15.5%. That's huge.
Exactly. Then contrast that with, say, 2020, during the pandemic economic shock. The repo rate plunged and the prescribed rate followed, dropping down to just 7.00% for over a year. And then, more recently, as inflation took off, we saw it climb right back up, hitting 11.75% for a good chunk of time between 2023 and 2024.
Those swings really drive home the point, don't they? This default rate isn't just some technical number. It's a moving target you absolutely have to watch in any commercial fight or when you're assessing legal risk.
Absolutely. In the end, the Prescribed Rate of Interest Act is like the essential legal safety net. It makes sure that even when there's confusion or silence in a contract or a full-blown dispute, there's a clear, legally solid, and, importantly, economically relevant way to figure out the real cost of delaying payment.
Okay, that really clarifies things. Which brings us to our final thought for you, the listener, to chew on. We know the default rate is locked to the repo rate, plus that standard 3.5%. And we know courts can step in if there are special circumstances. So here's a question. What kind of situation, what specific facts might make a judge look at that standard 3.5% premium and say, you know what, for this particular debt, maybe involving a really unusual, super low-risk deal, applying that standard premium just wouldn't be fair or commercially sensible. It's that tension, isn't it, between the clear rule and the judge's sense of justice. Something to think about. Thanks for joining us for this deep dive. Hopefully understanding this act gives you a bit more power when you're dealing with the crossover of law and money.